And good evening from central London. I'm excited to go live today. And today we are talking about the Renters' Rights Bill update, and a lot happening over the course of the last couple of weeks, including but not exclusively the amendments, but also the committee stage that happened on the 14th of January. So very fresh news, and what I want to be doing is diving deep into the Renters' Rights Bills, and we'll be looking at a few articles that have come out in the last few days. Some, of course, very happy with the progress, and some not so happy, especially if you are a landlord. I'm sure you're feeling quite nervous. But today, hopefully, we can have a little bit of clarity. We'll be going through the articles, and the way that we like to put these lives is that it is a Q&A. If you have any questions, put it forward. I will come to your questions, and we'll go through them slowly but surely. First off, I want to make sure that I'm getting any technical issues out the way. Want to make sure that everyone see me. If you give me a thumbs up, that would be fantastic. I can see a few people on already. Labour shit party. Thanks for sharing your opinion, Mark. And Sonia, glad to have you live. Danny, thank you. I'm glad to be live again. Hopefully we'll give some more clarity today. Want to make a disclaimer. This is in no way legal advice. If you want legal advice, you should get that from us, definitely from a solicitor and not from YouTube. Today, what I'm sharing is what I'm hearing on a day-to-day basis with landlords who I speak to here in central London and different parts of the UK. And of course, we do speak to a lot of legal advisors. Before we kick off, just to let you know, we also are holding a webinar in February, around about 4 weeks' time. The link is on the description. If you haven't done so already, do register. This is a webinar that we do every 3 months, and it goes even deeper than the videos that we do live on YouTube, because we have guests, whether that's legal experts, tax experts, and so forth. It's one that you do not want to miss. So make sure you register. The link will be on the description. I think it's property updates, and then you have the link. Make sure you subscribe to that. So without further ado, I wanted to share with you this document, which is probably the most important document here with regards to the amendments. Now, let's start with a little bit of a history of this Renters' Rights Bill. So hopefully you can see my screen here, and we can see where this started. So you got first reading starting September 2024. That progressed in October, 2 in October, and then, or quite a few in October. Last one being Ways and Means Resolution on the 9th of October. Committee stage, 22nd of October 2024. And then it moved in January 14, report stage, third reading, which was the last one, of course, on the 14th of January 2025. What we do know is that this is going to be moving towards the House of Lords at some point this year. And timeline, we are expecting the Renters' Rights Bill to pass completely somewhere around about summer this year. Some people, some landlords are being optimistic and saying that probably the end of the year. I think it's going to be happening sort of the end of summer. So the actual, let me bring this up. This is the actual document, the legal document itself. Now, there's 40 pages here. We ain't going to go through each and every clause on this, because otherwise we'll be here probably 5 hours. I mean, if there's an appetite for that, for sure, let me know. Put a comment, and we'll probably do a 3-hour session, and we'll go through the whole document. Today, again, we're going to be going through some articles, and we're going to be breaking that down in a little bit more concise manner. This will be on the link as well, on the description, if you have the time and the appetite to go through it yourself. It will be in the description. If it's not, just put a comment through, and I'll make sure to just put that across on the comment section for everyone to download the link. Okay, great. So as we move forward, one of the ones that I want to start with in terms of the articles is this one here, which is from Property Mark. So, rent in advance limit included in Renters' Rights Bill as it moves to the House of Lords. Now, amendments from the committee stage were voted on the House of Commons before the bill completed its journey in the Commons on the 14th of January. Now, the bill now moves on the upper house for further scrutiny. Disappointingly, the UK government has far to refuse to reconsider the removal of the fixed term tenancies. That's going ahead. Property Mark again probably naively thought that that perhaps was something that they will change. No changes there. Definitely the Renters' Rights Bill will be moving forward with the abolishment of fixed term tenancies. Now, if you're not familiar as to what that means, at the moment, the standard tenancy, at least, which most landlords will have, will be the short hold tenancy agreements, and that has a start date and an end date. Now, what they're proposing here with the Renters' Rights Bill is that's going to be abolished. Now, what contracts in layman terms, at least, they're going to be rolling contracts, what we call periodic tenancies. So that's one part. Okay, so which means that you can't ask your tenant to leave the property as you would have with the Section 21, which currently exists, because Section 21 is also going to be abolished, and we'll talk a little bit more about that as well. So a tenant can move into the property and it will be indefinite until the tenant does have the right, by the way, to give you 2 months notice. Now, the part that most landlords that I speak to on a day-to-day basis are most concerned about is the fact that the tenant can move in and within the first day can give notice to move out. So effectively, they can be there for 3 months. Now, a lot of landlords are concerned about, well, hang on, how does that work? I use agents and I'll be paying thousands of pounds to an agent for a tenant, and then the tenant just leaves in 3 months. I'm pretty sure agents will adapt, and therefore being fair to everyone in the process, because that just simply doesn't sound like a win-win for both parties. So I'm sure the way that letting agents and property managers actually charge the fees will change accordingly as well. And actually, it will be interesting to do a video just based on that. What does that look like from an agent's point of view, and how you pay fees, and what agents are predicting, or at least what agents are anticipating the way that they're going to be working moving forward. Remember, guys, the way that we see the lettings industry is the end of an era. So this is something monumental. It's something that the biggest change in the letting industry that we've seen in a generation. So everyone is looking to adapt as this Renters' Rights Bill continues to progress. So again, a tenant can move in, can stay 5 years, 6 years if they don't give notice. There is a way whereby landlords can give notice for the tenant to vacate, and we'll share a little bit more about that as well. So based on this article, we have, despite challenges, it has been confirmed that the bill will not contain any regulations for minimum EPC standards, which will be separately consulted by the Department of Energy Security and Zero in the coming months. Well, Mr. Miliband can share more information on that in weeks to come. Any comments on the EPC, please leave a comment below, but that's going to be dealt with separately. So key amendments now included in the bill: limiting rent in advance. By preventing tenants from paying rent up front, the UK government will potentially reduce the housing options available to financially vulnerable people. People on fixed incomes like pensions, those with lower incomes, the self-employed and overseas students may have challenges passing referencing and affordability checks. Paying a larger proportion of rent at the start of a tenancy gives tenants an alternative way to evidence their ability to sustain tenancy, giving landlords confidence in renting. Okay, so what does this mean? So currently in the current system, let me just stop this sharing for one moment. So based on the current system, if you're a landlord, you invite, of course, people to view the property. They come and view the property and you choose the best of the batch. Now, sometimes in this scenario, let's say a tenant is a student and can't prove the way that they are going to pay for the rent. So it's standard in the industry that the landlord says, well, Mr. Student, pay 6 months, 12 months in advance, and then I'll consider you. If you don't, then I won't consider you because you're a liability. You're a bigger risk to me, as opposed to this other tenant who has financial references, works here in the UK, and so forth. So that's what happens right now in terms of the rental system. Now, with this renters' rights bill coming into play, that's going to be taken away. So why would a landlord risk taking a student whereby the landlord will no longer be able to add that certain amount of certainty and take away the risk? They wouldn't. So this article, what's saying is that students, let me bring this up again. And the students is just one example, but there are many other examples, as it says here. You got pensioners, self-employed people. These people are going to be put at a disadvantage because landlords simply won't take the risk and will take just people who, on paper, actually do pass referencing. And that how that's going to play out, I'm not exactly sure, but they will be at a disadvantage. So this is definitely something that the Labour Party have missed and simply do not understand the industry. So paying a larger proportion of rent at the start of the tenancy gives tenants an alternative way to evidence their ability to sustain a tenancy, giving landlords confidence in renting. So Housing Minister Matthew Pennicott stated that landlords still have the ability to request 1 month's rent in advance, along a security deposit of 5 or 6 weeks' rent. He went on to say that the use of referencing and affordability checks and the ability to request guarantors should be enough to give landlords confidence. So let's break this down. Affordability checks and the ability to request guarantors. So in the example of a student or someone coming from overseas who haven't quite secured their next job, they're not going to have a UK guarantor. And I promise you, you're not going to consider an international guarantor. There's just no way, because that's just not going to give you the confidence or the security that a landlord needs. So what happens there with someone that comes from abroad? Again, they're going to be put at a disadvantage. Same way, affordability checks. If you've just come to the UK, how are you going to run those affordability checks? It's limited as to what you can do. So let's see if there's any questions before we move on to the next section. So we have here Andrew. Danny, how do you think smaller landlords like me will manage all these changes compared to the bigger players? Well, you've got to get educated, Andrew. That's just the simple answer to that. There are tons of landlords organizations out there, whether it's Property Mark, National Residential Landlords Associations. The alternative to that is hire a property professional, because you will be putting yourself at risk. So we have another one here by Amrita. If I want to sell my property, what kind of proof will I need to provide to avoid issues with the tenant? Well, great question. I don't know what type of proof that is. We're going to go into that a little bit, Amrita, but my understanding is that the proof doesn't have to be on the front end. So, for example, if you want to sell your property and this renters' rights bill is already in force, you can ask your tenant to leave based on the grounds that the grounds that the government is going to allow you to ask that tenant to leave. At that point, my understanding is you don't have to give any proof. The proof, or at least the government or the council or the tenant's the one that needs to prove that you didn't go on to sell your property a few months after asking that tenant to vacate. Again, we are getting a little bit more information as to what that looks like. Right now, that's a little bit vague. Okay, so what's stopping tenants from abusing this compensation clause? how can we protect ourselves? I'm not sure which compensation clause you refer to, Leslie. If you can elaborate on that, that would be great. Okay, so do you think that the tribunal process for rent increase will be fair, or will it lean heavily in favor of the tenants? Uh, Well, I would hope it won't lean in favor of any of the parties, whether it's tenants or landlords, Sonia. I would expect it to lean towards evidence, market rates, and what the market is doing currently. So it should be evidence based. There is, when it comes to valuations or when it comes to determining the correct rent or market rent, there is both a science and an art to it. I'll say 80% science, 20% art to it. But yeah, that's what I would expect to happen throughout the tribunal, which we'll talk a little bit more about in a bit as well. So, guys, if you're just jumping in, we are talking about the Renters' Rights Bill and the changes that have happened in the last week, of course, with the amendments and also passing through the committee stage on the 14th of January in the House of Commons. And what we're going to see is this moving across to the House of Lords. So, eviction grounds for student tenancies. So the bill currently only makes eviction grounds 4A available for students, HMOs, if the tenancy is signed less than 6 months before its start date. However, it's common practice for student agreements to be signed up to a year in advance, driven by students who want to ensure that they have secured accommodation. So if you're not familiar with these guys, this again, it makes eviction ground 4A available for students for HMOs. But this eviction ground is only based on tenancies that have been signed less than 6 months before the start of the day. Now, what this article is arguing is that a lot of students actually signed their tenancies 6 months, 8 months, even up to a year before their tenancy starts, to secure their tenancy when they come to the city, wherever they're going to be studying, because it becomes really crazy if they leave it to the very last moment. It's so competitive. At least that's the method here in London. Now, what it's saying is that this ground will only be available if it's signed within that 6-month period before it starts, which is crap for a lot of landlords who do secure their tenants a year before, 8 months, whatever that may be. If ground A cannot be used, it could interfere with landlords regaining possessions of their property ahead of each academic year, impacting future tenancies. Furthermore, this ground does not apply to 1 and 2 bedrooms, non-HMO properties rented to students, leading to serious concern that property owners will not have enough security to continue offering their properties to students, reducing the availability to decent accommodation for accommodation people. So, again, from what I understand from this eviction is that those landlords who do rent out to students, they're going to have an extra layer, or let's call it an eviction card that they can pull out, but it has to be within this time frame. Now, what's also crap about this ground is that it also has to be a HMO. So if you rent out to students and it's not a HMO, let's say you rent out to 1 or 2 students, then you won't have the ability to execute on this ground. I hope that makes sense. Anyone here that rents out to students, please feel free to put a comment and we will I'll review your comment for sure. Okay. And I'm sure there's lots of people. I know lots of landlords, especially here in London, that rent out to students specifically. Whether they're going to change that strategy with these new laws, that remains to be seen. So, landlords' fees to fund the Ombudsman. Fees paid by landlords will directly fund the creation and work of the private renters sector Ombudsman, providing renters and landlords with access to an effective and fair dispute resolution. Now, You might not like me for this one, guys, but I agree with the Ombudsman for landlords. I don't necessarily agree with the fees, or I'm not sure how much they're going to charge. I hope that they are reasonable. But I do agree that landlords should have the Ombudsman, tenants should have the ability to go to a Ombudsman to resolve any issues. Currently, agents do have to have an Ombudsman. It's law, and every agent needs to have that in place. Now, it doesn't really seem fair on the tenant, at least. If they go through an agent, great, they have a layer of protection there to put complaints. But then if they go directly to a landlord, then somehow the landlord sort of bypasses that, and the tenant no longer has a layer of protection to be able to put those complaints. Well, no, this is a good thing, guys. Let's standardize, let's professionalize the industry, because at the moment there's a lot of rogue landlords, and I know I say a lot, but within the context as well of that, I know they are in the minority, but there are quite a few out there. So let's proceed and let's see if this helps sort of weed out the bad guys. Okay, so what else do we have here? Guarantors cannot be liable after a tenant dies. So, this amendment prevents an individual guarantor from being asked to pay rent for a property after the person or people they are standing guarantors for dies. Housing Secretary Angela Rayner commented that this will safeguard bereaved guarantors, often family members, against financial hardship during the time of grief. Be interested to find out your views on these, guys. Fair, not fair? On the surface of it, it actually sounds fair. So I don't think everything in the Renters' Rights Bill is bad news. Again, if you disagree, let me know. We can agree to disagree. That's absolutely fine. So, private rental sector database. This is one I strongly disagree, and I'm gonna explain why. So, private rental sector database. The UK government has now set out the information that will be required about the landlord and the properties they rent out. This includes the name, address, and contact details of landlords and managing agents, details of any enforcement actions taken against the landlord or agent, and details of any previous evictions notices that have been served to a tenant. Registration will be compulsory, and costs will be covered by fees landlords pay. Okay, any opinions, let me know. And I want to share with you why I completely disagree with this. If you've been following our content, I did a live stream last week with regards to more bad news for landlords, and it was within the context of the selective license. Now, if you're not familiar with a selective license, this is where councils force landlords to pay a fee for a license, and this helps them to make sure that they can provide better housing options and standards within a region or neighborhood. Now, the whole point of this national database was indeed to be able to have a more simple and collective alternative to this license. Why would you need to double up? You have a national database that should be enough, and more than enough than this license councils have. This is a cash cow, especially when it comes from the council. Now, this selective license became more problematic on the 23rd, I believe, of December 2024. So literally, I'm talking about 3 weeks ago. Why did it become more problematic? Well, because previously the councils had to go and get confirmation from the Secretary of State to be able to get this approved in terms of regions or councils being able to request selective licenses within a borough or a region. Now, on the 23rd of December, what's happened is that the central government have actually given those powers to the council. So no longer do the councils need to go to the central government to get confirmation on this. And since then, the amount of applications or consultations that are currently live goes across the country, including London. Now, Westminster is one of the ones that have already made application for several locations across the borough. So again, there is an element of this, guys, that it's a cash cow, especially when it comes with the councils. I'm going to stop there. I'm going to start going through a few comments here and questions. Okay, so we've got one here from, won't these changes just make it easier for tenants to leave quickly and leave landlords in a tough spot financially? Well, yeah, to an extent, I will say yes, because landlords always like to have certainty, right? I'm renting my property now for 6 months or a year, and they know that it's done. They don't have to worry about it. Now they won't have that certainty. To give you some peace of mind, wise process is that what we do know, especially over the course of recent years, is that the average term that a tenant stays currently is around about 4 years. So they do renew their tenancies. So that should give you some peace of mind, at least. That should give you some peace of mind that tenants aren't really moving every few months. And of course, there are some people who are going to take advantage of this policy. And maybe that's something that they will do because they're in a position of doing that. But most tenants, the majority, it doesn't seem that way. That's not what the evidence tells us. The evidence tells us that on average, tenants are staying 4 years in their current property. So hopefully it won't be an issue. Okay, so Jonathan, how do you suggest we prepare for all the extra costs these rules might bring, like constant repairs between short tenancies? Great question. And there's an article I wanted to share with regards to that. And it's not so much, well, it's partly repairs. So there is an issue here. So if you remember back in 2019, we had the Tenant Fee Act, right? And that Tenant Fee Act now prohibits landlords or agents to charge tenants for any fees. Now, some of those fees included, not exclusively, included checkout fees, so inventory clerk, the actual inventory report itself, check-in, check-out, and so forth. Now, the landlord now has to pay that themselves. Now, when this happened, rent increased substantially. They increased. It took a bit of time, but it increased. And a lot of that was due to the Tenant Fee Act. Now, this adds another layer of pain because the landlord took the brunt of that. They took that fee on board themselves, understanding that they had to pay this every year or 2 years. Check in, check out. It's now the landlord's responsibility. Now, what we're saying is, with this new law that comes into play, well, now they potentially need to pay this every 3 months or 6 months if there's a turnover of tenants within that period. Crazy, I know. This is why we anticipate that rents will continue to increase over the course when this Renters' Rights Bill. And not only because of that, not only because of the short-term rental now, that periodic tenancy, but it's also an element of the end of the bidding rent awards, which also is part of the Renters' Rights Bill. So let me explain. If you were on my live stream last week, you'll understand this as well. So this is why I anticipate rents will increase sharply within the 12 months that the Renters' Rights Bill will come into force, within the first 12 or 24 months. So the Renters' Rights Bill will look to abolish bidding wars in the rental industry, meaning that if a tenant sees a property and they really like it and they actually want to secure it, and that property is being advertised for £2,000, it's very common ground that a tenant will say, I'll give you £2,100 because I know that £2,000 is a great price, right? And because I don't want to risk losing the property. So now that's going to be abolished. So now landlords, when they're going to put the property onto the market, if they think the property is worth £2,100, but dare I say it, maybe they're going to go for the above, or dare I say it, even top or above market price, because they don't want to feel that they've left money on the table. So that's exactly what's going to happen once this new law comes into play. Okay, so remember, guys, just a quick heads up. we are holding a webinar. It's a very important webinar in February, whereby the renters' rights bill is going to be broken down, but there's going to be experts on this webinar, legal experts, potentially, and also tax experts. So if there's something of interest, the link is on the description. Make sure you register. So, but Danny, what's your advice for landlords managing properties remotely with all these new compliance requirements? Again, my advice is you either get educated with so many organizations that are out there, take the time, educate yourself, take a few courses, and make sure you're not falling foul of the law. There's a new video coming out on Saturday. It's a short video, but it is talking about £30,000 plus fines that landlords are exposing themselves right now. So if you're not subscribed to the channel, make sure you do so you don't miss that. So get educated or hire a professional agent. And by the way, that won't save you alone. If a property professional fails to comply, ultimately you as a landlord are responsible. So it's not just about throwing that across to a property professional, because you're still liable. Make sure that that property professional has good reputation. Review their Google reviews. Look at how long they've been in the industry. Those type of things. If someone's been in the industry for a couple of years only, I would question on how much confidence you're going to put on that agent. My son is in the fourth year renter in Myland E3. Okay. Thank you for sharing that, exotic and dull. And hopefully your son won't have challenges. I mean, his fourth year is probably not going to it's not going to be a challenge for him. Probably graduates by then. But again, I do expect students to have challenges renting properties with this renters' rights bill. If I have a leasehold property where pets aren't allowed, how do I handle a tenant insisting they can have one? So remember, it's not about whether they insist, Jonathan, with regards to pets. They can put a request, and it's down to the landlord to prove as to why it's reasonable for them to decline that request. So it doesn't give them automatically a green card that they must consent. So yes, if you have a head lease that prohibits it, then that potentially could be a reason a valid reason why you cannot allow pets. Whether they'll go as far as to asking the head lease, so the freeholder, to prove why it's reasonable for people not to have pets in the building, I don't know, but certainly something to catch up on. We've got Mark Robinson. Perhaps there should not be IHT. I'm trying to work that out. Then if you are upset at a loss of someone, RE guarantor not liable if tenant dies. Let me come back to you on that one, Mark. So we have Ash J. I can't find any info on how long these licenses last. I need to apply for one, but have no clue what their duration would be. So selective licenses typically will run for 5 years, and then you will have to renew that. So Sonia, if a tenant are challenging rent increasing more often, won't this discourage landlords from making upgrades and improvements? Great question. So, I mean, tenants can challenge it. My concern with tenants challenging rents is more so because it doesn't cost them anything. So whether they know it's actually market rent or lower or even lower, it means they can send this to the tribunal. Now, I don't know what the time frame is for the tribunal to actually pick this up, but the issue with this new renters' rights bill is that from the time that you request that rent to be increased and the tribunal to actually review it and give their opinion on it or put their stamp of approval, whether it's, let's say it's 3 months, it won't be backdated. So you will lose 3 months. So let's say if the tribunal agreed, actually that rent is more than reasonable. Absolutely. Here you are. You have the stamp of approval. If 3 months have gone past, they won't backdate it from the time that you've requested that rent increase. That's the issue that I have with that. So, going back to this article, we have this database, as we discussed before. So, the UK government now has set information required. I think we talked about this already, and it's going to be covered by the landlord, the council, the selective licenses is also covered by the landlords, by the way, remember? So, home adaptations for disabled tenants. Although this amendment was withdrawn before the vote, Pennycook gave assurances that it would be discussed further at the next stage. Proposal will allow disabled tenants to have a right to appeal if landlords do not agree to adaptations recommended by local authorities. Okay, so that's a nice sort of breakdown from Property Mark as to the amendments and what they can see moving forward. Now, I wanted to share with you some other articles here, which I found quite interesting. Let's go into this one, which is Matthew Pennycook. So here we are. Renters' Rights Bill passes third reading. And here you are, Matthew Pennycook. Okay. So what we have here, the Renters' Rights Bill passed the third reading, as we know. Matthew Pennycook, Housing Minister, addressed concerns about the move, saying there's still an option for landlord requesting a guarantor using landlord insurance. This is, of course, is within the context of requesting rent in advance. Pennycook, speaking in Parliament for the third reading, said requiring multiple months of rent from a tenant in advance when agreeing a tenancy is unfair, places considerable strain on tenants, and can exclude some people and families from renting altogether. I find this bizarre, but this is now going to put people who are vulnerable, even bigger challenge, because at least before, if they had the option of putting rent in advance and saying, I know I'm a liability because X, Y, and Z, here's some rent in advance. Now they won't be able to do that, and the landlord won't even consider them at all. Landlords will continue to be able to take a holding deposit of up to 1 week. Yeah, we know this, or 5 or 6 weeks holding deposit, security deposit, sorry. They will also be free to undertake the necessary referencing and affordability checks. So, if and when there are not satisfied by outcomes of pre-tenancy share, options are available to tenants and landlords to ensure that a rent in advance need to be used, requesting a guarantor or engaging in landlord insurance, for example. Well, if they don't pass in referencings, they won't be insured. Again, it seems like politicians do not understand the rental industry. I'm all for leveling up the playing field on tenants and landlords, but what we have seen in the past is what the government actually does. And when they interfere with these things, they actually put tenants at a disadvantage, which is why we're here today. In terms of other amendments to the Rights Bill, so students can no longer be locked into a rental agreement more than 6 months in advance. The fee landlords will pay towards a national database. Okay, we talked about guarantor will not be liable for rent if tenant dies. Okay, so we've gone through this. So let's go on to this other one that perhaps provides a little bit more information. We have this one, which is interesting. So the courts, this came out, what's today? Today is the 16th. Came out today. Great. So courts won't cope with the Renters' Rights Bill, senior lawyers warning. A leading property dispute lawyer has highlighted a significant problem ahead due to the government not properly resourcing the courts to deal with the influx of claims. So the Renters' Rights Bill is now in the House of Lords. So the legislation will be a seismic change in how tenancies operate, a huge increase in regulation in landlord private sector. There are massively increased role for regulation by local authorities and hefty increase in level of fines they can issue. And again, you do want to look out for that video that comes out on Saturday. Do subscribe to the channel. We're talking about some hefty fines. Landlords who deliberately breach regulations can be fined up to £40,000 without a tribunal or court determination. This is crazy because councils are going to be out for blood. I'll tell you that much. The committee stages of the passage of this bill has made it clear that the government has no intention of properly resourcing the courts and tribunal to deal with the inevitable influx of claims and additionally requiring court time in dealing with disputes. Scott says Housing Minister Matthew Pennicuick said that the government will continue to work with courts and tribunals to ensure they have capacity, but refuse to be drawn into a formal assessment of what increase in claims can be expected for a review as to how the increase will be dealt with. Scott continues, the minister instead relied on the unevidenced assumption that tenants would only resort to tribunals or courts as a last resort, rather than to secure a negotiating advantage or a delay in the implementation of a rent increase. I mean, it won't cost tenants anything, my understanding, diverting this to a tribunal. So why wouldn't they do that from the very beginning? Why would they leave it as a last resort? They just simply wouldn't. Okay, so possession claims can take more than 4 to 5 months to get possession order. A year or more can have passed without landlord receiving rents before non-paying tenants is evicted. And this has happened time and time again across the country. And again, what I foresee with this happening is that less desirable areas that may attract less desirable tenants are going to be the areas that are going to suffer the most. I see that these are the areas where landlords are selling up the most. Of course, concerns on Section 21 and just in general, less powers to be able to get the property back. And of course, who is this going to concern the most? Those landlords that do have these properties where they get problematic tenants. This is unfortunate because again, it's a section of or a segment of renters that are going to be at the most risk. If they're vulnerable now, they're going to be even more vulnerable once this rental rights come in. Not only from a point of view that there's going to be less stock in those areas when increases, but also the little amount of properties that will be in this area for those landlords that have a stomach for risk. They are going to be much more selective with the tenants they choose. I hope this makes sense. Let's see if there's any other questions here. So what do we have here? So how do you balance being compliant with keeping costs down, especially if you're managing multiple properties? Great question, Edmund. Well, I guess you treat your properties as a business, which is the way that you should do. Buy-to-let is a business. I know people hate it, but this is the way the government has forced many landlords to treat their properties. I know a lot of landlords that got into the buy-to-let industry as a means to subsidize their pension. But now more and more people are selling up, and it is now left in the hands of landlords who do treat property like a business to make the numbers work. So that's how you balance it. You look at your numbers and you make it work. And with rents increasing, we've had double digits rent increase over the course of 3 years, over 30%. It is slower in terms of increase. They're not dropping, because I know that a lot of people confuse. Oh, rents are dropping. No, they're not dropping. They are slowing down. The speed at what they're increasing is slowing down. That's a difference. Fair enough, there might be some regions of the country that it might be dipping, but with everything that's going on, I'm sure properties will continue to increase in rent. Okay, so what else do we have here? Do you think that the tribunal process for rent increase will be fair, or will it lean more heavily against tenants? I think I've shared this one already. I hope it won't lean in any way, whether landlord or tenant. I hope that it actually leans towards evidence as to what rental market is. And I hope that they put competent people to deal with these rent reviews and give a fair and informative decision based on that. So before we jump to the next article, I think we have managed to actually go through all of the articles. So if there's no further questions, I think we're pretty much done. Thank you for jumping on. We do tend to jump on every Wednesday. Today is an exception. Every Wednesday between 6 and 7. If you haven't subscribed, registered to the webinar, which I promise you dives so much more deep as to what this is to keep yourself and your property safe. Make sure you do register on that webinar. The link will be on the description. It's under property updates, I believe, and we will have some special guests on that. And there's also some free resources on the link. Thank you very much, guys. Have a great evening, and I'll catch you next week. Thank you so much.